I would,
So why do we go around on YouTube?
because, court, in the state of Texas, we have to hold an open court that's open to the public. And if we're holding virtual hearings that the general public doesn't have access to, then we have to go out on YouTube. It's just live, we stream live after we have the hearing, we go in and delete it.
Yeah, it doesn't stay for the
No, it
next
won't stay.
15 years or anything.
But if you go to our YouTube channel, you can see some nice weddings that we've done in the past that we leave up.
So I'm gonna let these people in just so they can check in.
I think so, and announce what case they're in.
Candace, is there a defendant here on this case?
No, sir.
Okay. And the defendant was served?
Yes, sir. For this
Yeah.
docket, Judge, we only have one defendant. She's here in person, but we're not hearing that one just yet.
Okay, okay. Well, you may proceed when ready.
Judge, I've actually looked at y'all's file. It has the motion for default judgment. It has, they sent me, I've already looked at the affidavit of, the business records affidavits that is attached to the petition. It's all in order. It's a Lowe's credit card for it. The amounts on there, I verified the amount. I think it's $3,400 or something along that line. Here, I can tell you, I wrote it down. $5,392.93. They're not asking for attorney's fees. It's a standard credit card case. All of the business record affidavit meets the requirements. I always double check to make sure statute of limitations isn't an issue. So I've done that, whether people ask for it or not. I'm not going to let somebody get a judgment against them if the statute ran. But so bottom line is I request the court to sign the default judgment that is on file. I don't need a copy of it, so you don't have to worry. Just mail it to them whenever you do it. I passed me. I'm done.
Okay. I will sign that, Judge.
Okay. You have a good one. I like the roof of your car. You clearly have a sunroof.
Right.
Take care, Judge.
You do.
And we'll email a copy of that judgment. It'll be tomorrow.
Yeah, and I don't need it. Just send it to
them,
Midland
okay.
County. Not a big deal.
Okay, thank you.
Y'all have a blessed day.
Thanks for coming in.
Good morning. We have Miss Brandy Browning, case DC 210021 JP1.
Okay, there's some feedback, but I got most of it.
Is there anybody here on that case?
I'm sorry.
Oh, you're on mute.
Apologize. Mr. Stevens is here.
Okay, and is that your case?
Yes. Brandy Browning, yes. I represent LPNB.
Okay, I need to come up here. Wherever you're coming from.
Judge?
Yes.
Okay, so this is DC 210021 LVMB funding versus Brandy Browning, and we have both parties here.
Both parties are there in person.
Yes, we have Ms. Browning here in person, and then we have the attorney here on Zoom.
Okay. Would you see if they want to discuss this matter first? The attorney and the defendant.
Certainly. Yes, ma'am. Yes, sir.
Okay, we're gonna put y'all in a breakout room. Just give me 1 minute.
Yes, ma'am.
think it's, that is-
Oh,
Are you guys ready on that Calvary Keaton case yet?
Okay, Judge?
Yes.
Okay, So it looks like, they're done.
Yes, and he's gonna, send us an agreed judgment or something down the road, or?
Yes, sir. I provided her my contact information. She's going to reach out and we're going to connect to resolve this via our settlement. And we'll provide you with the agreed judgment and to close out this matter and move forward from there.
Very good.
Again, thank you, ma'am, for appearing.
Thank you.
So the judge is asking if you have any more cases.
I do, yes. I have 6 more, I believe. Yes, I have 6 more.
10:30,
I'm sorry?
at 10:30?
At 10:30, yes. They're all defaults, and if nobody else has appeared in the courtroom, I'm happy to go through the prove-ups, but I've already reviewed them all, and they all have the necessary information and documentation. If the court wants to take them by submission, that's fine with me. If he wants me to do a prove-up as to each, I can do that as well, whatever he prefers.
Okay.
But it may be simpler, given our communication effort here, for them just to be taken on submission. But again, I'll proceed as the court directs.
Judge,
Yes,
so he has 6 more.
he has 6 more
Yes,
for now.
yes, for 10:30.
Okay, do we want to do those next, or what do you want to do? Whatever you want to do. What do you want to do? Which case do you want to hear next? I'll let you decide that. I mean,
I just have the one for Calvary.
okay,
Okay.
let's hear that one.
Are you ready, Judge, or? I can't hear anything, Judge. Tom, can you hear the judge?
I cannot.
Tom, can you hear the judge?
No, I can.
Judge, can you hear them?
Yes, I can hear.
Let me know when you guys are ready.
Go ahead for DC 21-0021. Oh, I'm sorry. DC 21-0008.
Yes, Your Honor. Calvary SPV one LLC is the assignee of Citibank on a credit card account. The balance is $7,982.69. It was a Home Depot branded credit card with the last payment on August 4th of 2017.
Because they're ready.
Go ahead for DC 21-002.
Sounds like the YouTube feed is playing us back
Yeah.
over again.
Yeah, I just exit out, sorry.
No problem.
Mhm.
We've included with the application for default, a copy of the terms and condition statement showing the balance that we're seeking in the case, along with an assignment and bill of sale transferring this account to the plaintiff in the case. We would ask that the court enter a final default judgment. We've not received any communication from the defendant for 7982.69 plus post-judgment statutory interest at the rate of 5% and the cost of court.
And the court will sign that. We have a default judgment there, Stephanie.
Yes.
Okay, the court will sign that judgment.
Thank you, Judge. Be careful today and have a nice weekend.
You too, thanks.
Okay, so the rest of them are, we can go in any order. You can just let me know what case you're starting with.
Okay, I'll proceed then on the prove up. Let's see, we've already taken care of Miss Browning, so I have 086, capital one, Van Winkle.
Mhm.
Do you want me to go through all the numbers or just one at a time?
We can do one at a time.
Okay.
Mhm.
And are you ready, Stephanie?
Yes.
You may proceed, counsel.
Thank you, Judge. Yes, sir. This matter concerns a credit card account in default, set of credit card account being originated between Capital One Bank plaintiff and the defendant, Van Winkle, back in February 2016. The account was then put in default, failure to comply with terms of payment, and closed and charged off in August of 2019. The amount outstanding due and owing as of that date certain in default being $3,205.55, sought as liquidated damages by plaintiff, original creditor, Capital One Bank in this case. We have provided the court with a return of service, which has been on file with the clerk of the court for a sufficient number of days. No answer or otherwise appearance have been made by defendants in this case within the time period required by law. We filed our motion for default judgment, providing the certificate of last known address, non-military declaration as to defendant, as well as our affidavit and our business records related to said account, inclusive of account summaries, statements that were provided to defendant at defendant's address, said statements inclusive of the final amount showing at the time of closure of said account, which again was sought or is sought as provided in our petition and in our proposed judgment that was provided with our default judgment, our default motion for default judgment, excuse me. So at this time, we would ask for the court to render default judgment in favor of plaintiff and against defendant in this case for said amount, $3,205.55. We have waived post-judgment interest recovery. We are not seeking pre-judgment or attorney's fees. We are seeking cost support.
Okay, and we have a default judgment there, Stephanie.
Yes.
That judgment will be signed.
Thank you, Judge.
You're welcome. And you
What
may
am-
proceed on the next one.
Okay, Stephanie, are you ready for Palmer?
Yes.
Okay, perfect. Yes, sir. This matter also concerns a credit card account in default. Said credit card account was originated between Comenity Bank and the defendant Palmer back in October 2017. It was subsequently put into default for failure to comply with terms of payment, closed and charged off in November 2019. The amount outstanding due and owing as of that date certain at the time of default being $3,550.69, sought as liquidated damages in this case. Said account was subsequently sold, signed, conveyed, and transferred to current owner, assignee, Midland Credit Management, plaintiff in this case. We have the return of service that's been provided to the clerk of the court for a sufficient number of days. No answer or otherwise appearance have been made by defendant in this case within the time period required by law. We filed our motion for default judgment in this case, providing the certificate of last known address, non-military declaration as to defendant, as well as an affidavit as to said account and business records that were provided, inclusive of the bill of sale on said account and the credit card statements that were issued by the original creditor to the defendant at the defendant's address. Said credit card statements inclusive of the final amount showing at the time of closure on said account and default. The amount again being reflected as $3,550.69. For these reasons and based on such documentation, we ask for the court to render default judgment in favor of plaintiff and against defendant in this case. Our proposed default judgment we provided the court seeks set amount $3,550.69 plus cost of court. We are not seeking prejudgment interest. We are not seeking attorney's fees. We are, however, seeking 5% statutory interest in this case.
And we have a default judgment there, Stephanie.
Yes.
That judgment will be signed, counsel.
Thank you, Judge.
And you may proceed on the next one you're ready.
Yes, sir, Judge. With the next one we have is Bank of America. Bank of America and defendant NAG entered into a credit card agreement, which was originated back in May of 2015. And it was thereafter put into default for failure to comply with terms of payment. The amount outstanding due and owing as of the time of the closure and charge off of said account in November of 2018 is shown as $11,484.88. We have provided the court with the return of service, which has been on file with the clerk of the court for a sufficient number of days. No answer or otherwise appearance have been made by defendant in this case. We filed our motion for default judgment. Inclusive therewith is our certificate of last known address and non-military declaration as to the defendant, as well as our affidavit for our business records, inclusive of the account summaries and statements that were provided to the defendant at the defendant's address, which are also inclusive of the final statement reflective as the closure on said account for said default reason, which identifies the amount sought as liquidated damages in this case. We've also provided the court with our proposed default judgment in this case. We are not seeking prejudgment interest or attorney's fees. We have waived post-judgment interest. We're simply seeking damages and cost of court. Said damages again identified as $11,484.88.
And we have a copy of that default judgment.
Yes.
That judgment will be signed.
Thank you, Judge. The next case we have showing here is
Hold
a
on just a second.
certainly.
Do you have more cases this afternoon?
Yes, but not just, I have one at 1, but I think it's, I think there's a settlement involved, so I'm just seeking a continuance.
Okay.
And then I have 2 at 2, so not much.
Okay.
So,
Bring it back.
okay. The next case we're proceeding on is Jefferson Capital Systems. This is a case involving a credit card default. This credit card account was originated between WebBank and defendant Alvarez back in August of 2014, and it was subsequently put in default for failure to comply with terms of payment, closed and charged off in March of 2019. The amount due and owing as of that date certain being $2,564.32, sought as liquidated damages in this case. That account was sold, signed, conveyed, and transferred to Jefferson Capital Systems as current assignee owner of said account, who is plaintiff and brings this claim for said default account. We have our return of service that's been on file with the clerk of the court for a sufficient number of days. No answer having been filed or otherwise appearance made by defendant in this case. We filed our motion for default judgment, providing the court with our certificate of last known address and our non-military declaration as to defendant, as well as our account affidavit, business records, showing the bill of sale and transfer of said account to current plaintiff assignee, and as well as the credit card statements and summaries that were provided by the original creditor to the defendant in this case, inclusive of the closure on said account, identified said statement that contains and describes the amount sought at the time of closure, and which is our liquidated damages claim, the amount thereof as reflected in our proposed default judgment, again showing as $2,564.32. We are not seeking prejudgment. We are not seeking attorney's fees. We are seeking cost of court and 5% post-judgment statutory. For these reasons, based on said documentation, we ask for the court to render judgment in favor of plaintiff against defendant in this case.
And that judgment will be signed.
Thank you, Judge. We have two more remaining.
Okay.
The first one is Midland and defendant Poulter. This is a credit card account that is in default. Said account was originated between Capital One Bank and defendant Poulter back in July of 2013. It was subsequently thereafter put into default, failure to comply with terms of payment, closed and charged off in July of 2019. The amount due and owing as of that date certain being $8,280.18, sought as liquidated damages in this case. The account was then sold, signed, conveyed, and transferred to current assignee owner Midland Credit Management, plaintiff who brings said claim in this case, seeking such damages. We have the return of service that's been on file with the clerk of the court for a sufficient number of days. No answer or otherwise appearance having been made by defendant in this case. We filed our motion for default judgment. We have provided the court with a certificate of last known address and non-military declaration as to the defendant, as well as the affidavit as to the account and business records identifying the bill of sale, transfer of said account to plaintiff, as well as the credit card statements and summaries that were provided to defendant by the original creditor in this case, inclusive of the closing statement, identifying the final amount shown as being in default and owing in this case, for which our liquidated damages claim is brought. We have a proposed default judgment on file as well, which identifies said amount of damages as, again, $8,280.18. We are not seeking attorney's fees. We are not seeking prejudgment interest. We are seeking cost of court, and it does identify 5% statutory post-judgment as being sought as well. For these reasons, based on said documentation, we ask for default judgment be rendered in favor of plaintiff and against defendant in this case.
And that judgment will be signed.
Thank you, sir. Our final case for today. This matter concerns, this is a Midland Credit and defendant Sowell. This matter concerns a credit card account in default. Said account was originated by between Capital One Bank and defendant Sowell back in November of 2014. Said account was subsequently put in default, failure to comply with terms of payment, closed and charged off in August of 2018. The amount due and owing as of that date certain being $1,712.37, sought as liquidated damages in this case. The account was subsequently sold, signed, conveyed, and transferred to Midland Credit Management as current assignee owner of said account who brings this case as plaintiff. Our return of service has been on file with the clerk of court for sufficient number of days. No answer having been filed or otherwise appearance made by the defendant in this case. We filed our motion for default judgment, providing therewith our certificate of last known address and non-military declaration as to the defendant, as well as our affidavit as to our business records, inclusive of the bill of sale, identifying the transfer of said account to plaintiff, and the credit card statements and summaries that were provided by the original creditor to defendant at defendant's address, inclusive of the closing summary that identifies the amount shown as the damages claimed in this case on said defaulted account. We also have provided our proposed default judgment for purposes of the court's consideration that again identifies said damages as $1,712.37. We are not seeking prejudgment interest nor attorney's fees, but we are seeking cost of court and 5% post-judgment statutory. For these reasons, based on said documentation, we'd ask for the court to render judgment in favor of plaintiff and against defendant in this default proceeding.
signed.
Thank you, Judge. That concludes all the business I have before the court for this morning. I have a matter at 1 o'clock and 2 o'clock. Otherwise, I will see you there. If there is nothing else, I'm asked to be excused.
You may be excused. Thank you, counsel.
Thank you.
Thank you, sir. Thank you, Do you need anything from my end before 1 or 2 o'clock? Stephanie?
No,